Okay, we're on the record in the matter of the people of the state of Michigan versus Shakira Jackson, 25-01270. Yes, please.
Thank you, Your Honor. Cassie, could you for the people?
I'd like to get that of Mr. Jackson.
Mr. Jackson was scheduled today for preliminary examination for controlled substance delivery manufacturing and as a police officer assault resist obstruct. We're not running an exam, is that correct?
Yes, Your Honor. It's my understanding that the defendant intends to waive his right to preliminary exams to preserve an offer of the 4-year possession.
That's correct, Mr. Blackman?
It is.
Okay, and then Mr. Jackson, you understand your right to have a preliminary examination?
Yes, ma'am.
You understand that the purpose is to require the prosecutor establish that they have sufficient evidence to support probable cause that the crime was committed, and then probable cause sufficient to charge you as the person who committed the crime.
Yes, ma'am.
And you wish to unconditionally waive that today? Anyone promising you anything to get you to waive your exam?
Can you repeat that? I'm sorry.
Anyone promising you anything to get you to give up your right to exam today?
No, ma'am.
Any threats made to you if you give up your right to exam?
No, ma'am.
Your waiver is freely and voluntarily made. Your bind over date is going to be September 24th. That's the date. He can't listen to me if you're talking to him. That's the date that the circuit court receives the file from the district court. It's not a date that you need to appear at the circuit court, okay? So what's the head nod mean?
Yes, ma'am.
Thank you. Your next court date will be a pretrial. Your attorney will be made aware that you maintain communication with them. If you have any changes in your contact information, it's your responsibility to update the court as well as your attorney, okay?
Yes, ma'am.
Do you have any questions at this time?
Um,
Okay, no one completed the paperwork. I don't know why. Any additional matters for the record?
Not for the people, Your Honor.
Bond will continue. You gotta complete the bind over paperwork.
Oh, yes, I understand that. Thanks.
Right here.
Record in the matter of the state of Michigan versus Jasmine Henderson. Evelyn Jackson. This is 25-02572-171. Appearances, please.
Thank you, Your Honor. Cassie, could you for the people?
Under Sheriff Kaplan, P74943, on behalf of the defendant, who's standing to my right. And I'm just completing the paperwork here, Your Honor. And to
Evelyn Jackson.
Yes, Your Honor.
Your appearance for the record.
Yes, Your Honor, Saranac on behalf of Ms. Jackson who is present.
So, Mr. Kaplan, my understanding is that your client is going to plead.
that's correct, Your Honor. There's an offer for her to plead to an attempted resisting obstructing. Prosecutor will agree to HIDA.
And Your Honor, have that plea sheet and advice for explanation. And that is an accurate statement of the offer.
Raise your right hand, ma'am. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, this is an advice of rights and plea information sheet. Is this your signature? Is that a yes? Did you go over these rights with your attorney? You understand all of these rights? Do you want to give these rights up today in order to plead guilty to the amended charge of attempted resist obstruct an officer? Okay, you understand that you have the right to the presumption that you're innocent. So you're innocent until proven guilty. You have the right to require the prosecutor prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial, not have silence be used against you. the right to see, hear, or question in court any witness called to testify against you, and the right to subpoena witnesses to testify on your behalf. You understand that? You want to give up all of those rights? Are you sure? Why are you looking off on the side of your head like you're not sure? Counsel, you don't have to stare at her. That could be intimidating. Okay, and no one's threatening you in order to make you to do this? Has there been any coercion to get you to waive your right to plead guilty?
No.
Are you pleading guilty because you believe you are guilty? Okay. Counsel, on factual basis.
Thank you, Your Honor. Ms. Henderson, on August 21st, 2025, at about 6:27 p.m., were you driving on East Mount Hope Avenue?
Yes.
And that was near South Pennsylvania Avenue, and that was in the city of Lansing. And your knowledge, that's in Ingham County, Michigan. And at that time, you were driving at around 48 miles an hour, 35 mile per hour zone, correct? Okay. Well, are you sure or you're not sure?
You can say if you're not sure.
You were pulled over at that time, though, for speeding, correct? The officer was in a fully marked police vehicle, correct? Lights and sirens,
Say yes.
Yes.
and he was in full uniform. And he approached your vehicle at some point and advised you that you had warrants, correct?
Correct.
And he ordered you to get out of the vehicle. Is that accurate?
Yes.
And you did not immediately get out of the vehicle. Is that correct?
Correct.
And you knew that he was a police officer in the process of doing his job, right?
Correct.
And because you had warrants, he was giving you a lawful command to get out of the vehicle, correct?
Correct.
That's all I had.
People have no additional questions. Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be free, voluntarily and intelligently made. This matter is set for sentencing October 31st at 9 o'clock in the morning.
Thank you, Your Honor.
Thank you. When you leave here today, ma'am, you have to go downstairs to meet with probation. They'll get you set up for a pre-sentence interview. And they'll advise the court if you're eligible for sentencing under HYTA, okay?
I can do that today.
When you leave here, you're going right downstairs to the fifth floor. Do you have any questions? And today, they're only setting you up or scheduling you for a pre-sentence interview. The interview won't take place today, but there's paperwork that you need to complete today before you leave this building so that they can schedule that, okay? Do you have any questions? Okay, any additional matters for the record on this line?
Not for the people,
Thank you, Your Honor.
not for the people either, Your Honor.
Thank you.
Thank you.
And then as to Ms. Jackson, it's like last week, Ms. Jackson attempted to plead, that plea failed. And that was because she said she never received a lawful command. See today.
Your Honor, the people have provided a amended offer at this time that is a plea to one count of attempt interference with police investigation, and I have the PAC code on the plea sheet. That is a 1 year misdemeanor that's brought down to 180 day by the attempt statute.
You have that on your plea sheet, you said?
Yes, Your Honor. May I?
Yes.
And I seem to be missing the second page of advice of rights, so I don't know if we need to find that page or where it has gone.
The one that she actually signed, you mean?
Correct, that's my concern.
Fine.
You say you didn't sign anything? That will explain
They've
it.
gotten torn beforehand.
She hasn't signed it yet.
Yeah, that's what I was saying. It may have gotten separated before. So I think for me, it's second to complete that part.
It's two separate pages, so.
Your Honor, may I approach?
Yes. Give him a copy. Okay, Ms. Jackson, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes,
Okay, you can put your hand down. And you understand the rights listed here?
yes,
You have any questions about any of these rights?
no,
You're willing to give these rights up in order to plead guilty to the amended charge of attempted interference with a police investigation?
yes,
You understand that that's still a misdemeanor, maximum penalty 180 days and or $500 in fines, correct?
correct,
And you also understand that there's no objection to sentencing under HYTA, correct?
correct,
Okay, and you have the right to the presumption of innocence. You're innocent until proven guilty. You can maintain your innocence and require the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt. You understand that?
yes,
You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses to testify at trial on your behalf, the right to remain silent and not have silence be used against you. You understand that?
yes,
And is anyone threatening you to give these rights up?
no,
Has there been any coercion to get you to plead guilty today?
no,
And no promises if you plead guilty?
no,
You're pleading guilty because you believe you are guilty.
yes,
As to the amended charge of interfering with the police investigation, how do you plead?
yes,
Factual basis?
Thank you, Your Honor. Ms. Jackson, I'm gonna take you back to August 21st. Do you recall getting a phone call from the Lansing Police Department?
for my girlfriend,
And your girlfriend is Jasmine Henderson?
yes,
And they had pulled over her vehicle and were conducting a investigation?
yes,
Okay. And when you arrived there, did you see the Lansing Police Department officers?
yes,
When you approached them, were you acting loud and boisterous at that time? And did that behavior interfere with the investigation you were doing on Ms. Henderson?
yes,
Your Honor, I have no further questions.
People have no further questions for the factual basis. Your Honor.
Thank you. The court is satisfied with the factual basis. I accept your plea and find your plea to be proved voluntarily and intelligently made. Your sentencing date is October 31st at 9 a.m. You'll go downstairs to probation today to get set up for your pre-sentence interview, okay? They'll also advise me as to whether or not you are eligible for sentencing under HYTA. Do you have any questions at this time?
no,
Any additional matters for the record, counsel?
No, Your Honor. Thank you.
No, Your Honor, thank you.
Thank you, you're all set. On the record in the matter of the state of Michigan versus Eric Metcalf, 25-02364, appearance, please.
Thank you, Your Honor. Cassidy, could you please for the people?
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Metcalf. And I've called Mr. Metcalf last night, see the number provided, called his name 3 times, stay in court, he is not present. I was just appointed to this matter yesterday. I was made aware by the assistant prosecuting attorney that he's in Indiana and appeared via Zoom. So I humbly ask the court for a brief adjournment.
The concern that the clerk has is he appeared last week virtually, and when he didn't realize his camera was on, he appeared to be engaging in the use of illicit drugs. I ordered him to be drug tested and to appear in person today. So I will be issuing a bench warrant.
Yes, sir.
I recognize that I believe he is on parole in Indiana, Allen County, in Fort Wayne. So I'm sure it's his parole officer likely has some connection or contact to where he is.
Your Honor, is that warrant going to be nationwide pickup since the defendant's out of state?
That is correct. Any additional matters for the record?
No, Your Honor.
Thank you.
Everybody have a good day.
Same to you. Thank you. On the record in the matter of the state of Michigan versus Tomas Riojas, 25-01776, appearances, please.
Thank you, Your Honor. Cassidy Kachukas for the people.
And thank you, Your Honor. Good morning, Jared Austin appearing on behalf of Mr. Riojas. He stands present to my right.
Today was the date that we scheduled a sentencing, and I think we set his alleged bond violation. How are we proceeding today?
Let me call the hall one last time for the victim on the bond violation, verify that she's not. She has appeared, and I just need one moment.
There's someone in the back with their hand raised.
Oh, hello, it's Margaret. Oh, never mind, the victim is here, so people would be ready to proceed with bond violation if the defense would like us to proceed with.
Thank you, Your Honor. I would ask if the court would consider, given that there has not been any further violations since this last one, and that Mr. Riojas did spend 7 days in jail on that violation, that the court would consider dismissing that violation, given that there has not been any additional allegations since that point. If that is not the case, and I think Mr. Riojas would be prepared to acknowledge that he violated that court's order. But I would ask if the court would consider dismissing, given he did spend some time in jail on that, and there has not been any further allegations of any violations since that point.
Further allegations doesn't mean that there hasn't been any violations. Picked up or stopped by the police and found in the car with the protected party. Let's see here. That was back in July. And the recommendation is for there to be 12-month probationary period for 769.4A. And a no contact order with the protected party that's here. Is that the request? I don't know, do they have children together?
Let me check and verify those.
They do have children in common, is my understanding. Your Honor.
They do have children in common?
Yes.
Okay. Did the, I'll proceed with the sentencing at this time. Did the Is there any changes that need to be made to the pre-sentence report?
I don't believe so, Your Honor. It appears to be accurate as well as complete.
Does the victim want to make a statement?
Um, She has indicated that she does not want to make a statement sentencing now.
No contact order will continue. You can make allocution.
Thank you, Your Honor. Your Honor, I would note some positives from the pre-sentence investigation report that Mr. Riojas, he has admitted to his wrongdoing in this case. He admitted his guilt before the court. As the pre-sentence interviewer noted, he appeared to be genuinely remorseful during his pre-sentence interview. And during that interview, Mr. Riojas recognized that he had multiple opportunities to remove himself from that situation or to act different. Positively speaking, Mr. Riojas is working, so he's gainfully employed. He was attending barber school that was temporarily put on hold while this case is pending. I believe at some point, Mr. Riojas has intentions to go back and finish his schooling there to earn a trade. Certainly, Your Honor, Mr. Riojas was to be given the opportunity, if he was successful at earning a non-public suppressed record for this case, that would certainly greatly benefit him in his future endeavors as relates to employment, housing. That's something he would benefit from for the rest of his life by not having to report this conviction on his record. So he's doing a lot of things, I think, to better himself, to give himself and his children a brighter future. It appears that he has no prior criminal history. And I know there was an initial allegation that he violated the court's no contact order, which the court, understandably so, treats very seriously. But it appears that there has not been any further allegations of any type that Mr. Riojas has violated his bond since that point. I think all of this demonstrates that Mr. Riojas is capable of being rehabilitated and can conform himself and follow court's orders. I do find the recommendation to be appropriate. I would ask the court to adopt them and to sentence Mr. Riojas forward.
Mr. Riojas. Mr. Riojas had something he wants to say?
I believe so.
Yeah, so I got out of jail on the 17th. I had court on the 18th. PPO got removed. It got terminated by Judge Garcia.
I don't even know if I had any information regarding the PO, but okay.
That was it.
Yeah, that was not a part of my file. But you still had a protective order here because the court entered a no contact order. And so anytime there's an assaultive case pending or allegations of assaultive action, the court more likely than not is going to enter a no contact order. So you were advised of that, sir, back on the 29th when you were arraigned. And so you were allegedly picked up by police. I recognize the prosecution was relying on the victim to appear, but they could have just had the police appear. You were picked up by the police with the victim in the car. And I recognize that you have children with this person, but this is a case that was originally charged with a felony of assault with intent to do great bodily harm to someone that bore children for you. And I said this, I believe, to you before, but I'm going to say it again. Women in general should feel protected by men. They should feel protected by their fathers. They should feel protected by their brothers. They should certainly feel protected by people that they're in a romantic relationship with and those who they have bore children for. You should feel like a protector, whether you're with in relationship with her anymore or not. She is the mother of your children. Your children should feel like their father is protective of them. And by protecting them, that means you need to protect their mother, even if you don't like her behavior. And there's a way to redirect bad behavior if that's what you're receiving from the other party without you resorting to violence or degrading her or yourself. You should never find yourself here with the no contact order with the person you have to help parent children with. And you can't be a good parent if you are in jail. You can't parent at all. And so I hope that this is something that becomes a life lesson for you. You're quite young. I'm assuming that you must have young children with the victim in this matter because of your ages, but hopefully this is a learning lesson and you move forward in a different direction. You need to get some counseling, and the court's going to order that you get some counseling. I would hope that the victim gets her own counseling, and that at some point, if you haven't done so, or if it hasn't been ordered, you do some parenting classes, because it's your job to rear and take care of little people, and they're looking to you and your behavior to see what's appropriate and what's not appropriate. And you can cause trauma to these children that could be cyclical, meaning they'll continue to make the same mistakes that you made because they see you do it and they're traumatized by it. You don't want that. You want your children to do better than what you did. And that means that you're going to have to work hard and create opportunities for them that maybe you didn't have. And I don't know what your father figure was in your life. But it's important for you now to change that cycle and be a good father and a good example for your children. Otherwise, if you continue on this path, which you don't have much of a interaction with the criminal justice prior to this, but if you continue on this, you'll end up in prison. And I don't think that's what you want. You don't present to me as someone who wants to spend their life in prison, sir. I'm going to withdraw the PA 53 at this time. I'm going to adopt the recommendation. You will be put on a probationary period of 12 months with the following conditions. You must maintain your employment and provide evidence of that to your probation officer. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You're not to be at any bars or nightclubs, and you must participate in random preliminary breath testing and urinalysis testing, okay? I'm going to order that you complete a domestic violence programming. I'll suspend the urinalysis testing after 90 days if you had no violations. I'm going to order that you enroll in a GED program if you've not already enrolled, okay? And you need to provide evidence of that as well. It does say that you're currently in barber school. Okay, you can provide evidence of that in lieu of enrollment in a GED program, okay? You have any questions at this time? It's a $30 per month oversight fee that you're responsible for each month of probation. So for 12 months, that's $360. There's a $75 crime victim rights fee that will be assessed. Plus a $50 state minimum cost that will be assessed. This paperwork I have looks different. So they moved some things around. I'm trying to understand why the attorney fees right there. I'll waive discretionary fines and costs. I don't believe there's any restitution at this time. You'll have the opportunity to make monthly payments on this, okay? The total fines and costs is $485, okay? Or a term of probation that does not make you eligible for early discharge, so I won't bother with that. You'll check in with probation before you leave here today. You will be reporting to them remotely via Zoom, okay? Do you have any questions at this time?
Just one.
Yes.
Do I gotta keep my tether on?
No, you do not.
I get it removed today?
You can go back down and have it removed today. I am continuing the no contact order at this time, right?
For the whole 12 months?
At this time, it will be continued. If the victim would like to have it removed, she's gotta come back up to the court and request that from me herself, okay?
Yes.
Any additional matters for the record?
Just briefly, Your Honor, if Mr. Yohas is struggling to find where to begin when he goes to his batteries intervention course, I would recommend that he bring his statement from the pre-sentence interview and be able to discuss that with people at that course. As I am seeing two slices of the power and control wheel being demonstrated in that, particularly using children and minimizing and blaming, just so he has a starting place when he does go through that batteries intervention.
Thank you. Any other questions or issues to address on the record?
I have nothing additional back from Mr. Riojas this time, Your Honor. Thank you.
Thank you. Best wishes to you, sir. I saw Mr. Silverthorne, but I don't know if he's still outside. On the record in the matter of the state of Michigan versus Jose Tucker, 25-02576.
Your Honor, the people actually, we're not bringing on Tucker quite yet. I need to check to see who's here on that.
We can do the pre-sentence. He's in court.
Sorry, I'm not following. That was at 8:30.
Yes, Your Honor, I was waiting for Mr. Palmer and to double check everyone else one last time.
It was an hour and a half ago. They were supposed to be here.
I'll get Mr. Tucker in court, Judge, he's sitting in the hall.
Thank you.
And I also have Mr. Evans, who's present here. That's a competency referral.
I'm on the record on Tucker.
Okay. Mr. Tucker, you can probably just come right up here with me. Stand right here where I'm standing. Okay.
So the people are ready at this time, Your Honor, and I believe there will be a motion. from the defense.
Okay, so we're not running an exam today.
No, Your Honor.
Counsel?
Thank you, Your Honor. At this point, defense moves to dismiss for lack of probable cause.
Your motion to dismiss is granted without prejudice. The people do have the right to reissue this against you. You understand that? They reissue it, you have to be rearranged, okay?
Judge, the only other thing I would ask is that Mr. Tucker does have a tether on, so I would just ask that the court contact JSG.
That will be taken care of. You can go back down and have your tether removed, okay? Take your dismissal in just a moment.
Thank you, Judge.
Okay.
Just sit in the hallway, go bring it. Yep.
Okay, on the record in the matter of the state of Michigan versus the priest Evans, 25-02611, appearance please.
Thank you, Your Honor. Can I seek to for the people?
Thank you, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Mr. Priest Evans, who is approaching the table now. And Your Honor, at this time, the defense is moving for regarding competency. I have paperwork.
Yes. And I noted that we would treat today as a probable cause conference, but it was anticipated that a competency referral would be made. Until the court isn't received the paperwork, get a copy of this to the defendant out there.
Yep.
We'll make the court will sign an order the defendant to undergo a competency evaluation at the Center of Forensic. Let's see. We don't have an address for him. We don't have contact information. So how is the Forensic Center supposed to get in contact with him?
I do have a phone number for him, Judge, because he's communicated with me quite a bit on his telephone.
Where is he living?
11:15 West Ottawa.
15 what?
11:15.
West Ottawa. Right now.
Okay, and the phone number?
489-0762. That's their code files.
Okay. So we shouldn't have any problems with him responding and handling his competency evaluation.
I do not anticipate any problems, Judge. Mr. Evans and I have been in good contact. We've talked on the phone several times. He's traveled to my office to review discovery and that kind of thing. So Mr. Evans is staying in good contact with me. I don't have any concerns in that regard. He hasn't done anything to suggest otherwise.
Very good.
Judge, the one other thing, I guess Mr. Evans has just asked me if the court would consider removing his tether. He is currently wearing a tether. He understands that he has a no contact order in place. He understands that he must comply by all terms and conditions of bond otherwise, but I would ask that the court consider removing.
Does he have a pending mental order in circuit court?
Not that I'm aware of.
He was on his sentence. 2021, it's just listed as pending.
Let me see if I can look at it.
I have a lot of concerns about his prior criminal history, including the assaultive nature of the mental health concern, the multi-state criminal record with contacts in Florida, Arkansas, and obviously Michigan. And then this is a felony assault with intent to do great bodily harm, and then an aggravated assault.
I did attempt to locate that order you were talking about. The only thing I am seeing most recent, Mr. Evans from our office for circuit court looks like maybe 2020. It's 2021.
The report that came from
Oh,
Union County Pretrial Services said that there was a 2021 mental order pending.
Your Honor, Abigail Wilson, if I could interject.
Yes.
We do keep records of the mental orders that are filed in this county. However, they're located on our shared drive, not in our typical system. And unfortunately, the network is not allowing me to access it at this time.
Yeah, the original request, at least from the, let's see here. These allegations of threats to kill the victim and family members, alleged escalation of violence over time, a history of threatening and harassing behavior allegedly toward this victim or witness. And the people originally requested a bond of 25,000 cash surety with GPS tether. Let's see. He was supposed to undergo a CATS or CMH eval before release. It states that the allegations include unprovoked attack in broad daylight, resulting in the victim having to obtain emergency medical care. It does say the defendant was or has a significant mental health history and was found incompetent in 2021. I think GPS tether is warranted and under the circumstances. Let's see. It was a no contact order not to be within 2,000 feet of wherever the victim lives. And the address he just gave me is behind, it abuts that address.
I contacted both pretrial services and the GPS teller people themselves and asked them several different times and told me that they were not able to contact Mr. Simon Jackson. That that order is not becoming effective. I had no blackouts.
I don't know what you mean that order does not come in effect. You're not to be within 2,000 feet of wherever the person lives. And it was in the affidavit of probable cause of where the alleged location even was. And that the person lives there. At least that's what we were told. You're gonna have to keep the GPS tether for sure. So no, the motion to remove the GPS tether is denied. Any additional matters?
Not from the people this time, Your Honor.
Just as a point of clarification, then I guess, judges, the address that he provided to the court is within the exclusion zone of the tether, because he's been wearing a tether and I haven't received anything that indicates he's violated an exclusion zone.
The only thing I could imagine is that maybe the victim no longer lives there, but the victim was there or residing or owned that property, the alleged victim that is,
Right.
at the alleged time of the incident.
Understood.
So
I see. Judge. Thank you.
it says that that property backs up to 1115 Ottawa, West Ottawa.
Ma'am, Mr. Rajak, he has two houses, one that, one that says is adjacent to 1114 and the.
Yeah, it indicates that.
Yeah, and the other property is 1108, which is right.
That 1108 was the location of the alleged offense.
Your Honor, 1108 is also where we sent our subpoena.
The location of the alleged offense. I understand that. I agree. I don't know why it would not be within the exclusion zone. This will have to be. We'll have to contact JSG on this one to find out what's going on with the exclusion zone. Thank you. You're all set for today.
Yeah, no more, no earlier. Maybe.
All set. Mr. Silverthorne has State of Michigan versus Daniel Trevino, 25-02620, appearance, please.
Thank you, Your Honor. Cassie, could you just for the people?
Mr. Trino, come up with me before we start. Mr. Trino has a moderate hearing impairment. There be a device if you were.
I don't know if our device works. You can try it. It's fickle. Not others. You can try it.
Sorry. No.
We could attempt, if the court elevates the voice. I often, can you hear me?
I can hear you.
Okay. I guess the judge could speak with you and if you could indicate if you're here or sufficient.
Can you hear me?
I'm sorry,
Can you hear me?
a little bit, man.
I am battling a sinus infection. I'm not going to be able to yell. That's for sure. Can we use another cord? I don't know if that works. No,
Because it has to be connected to
it
that.
has to be connected to our we have to reset it and figure out another time to do the hearing situation. So what?
I'm gonna email them now. They can get somebody else. I'll just reset it for next week.
So apparently, you can actually do allegations of the assault.
Present day,
So-
his brother-in-law, Vince Cobb, who indicated that if he can see your lips, he often does that.
But that's not good for a plea. We gotta reset it. We're gonna reach out, it's JSG.
It's,
I mean,
DCR.
DCR. We gotta reach out to, reach out to have them come and fix our device.
Oh.
September 18th.
Would the court take he lives in Oceana County. In fact, tomorrow he's going to be in a rehab in Oceana County. Could he, if it's reset, could he appear by Zoom? I would appear in person.
Yes.
He could
We can appear by Zoom,
Well, that would be fine.
September 18th
At 9.
at 9.
Thank you, Your Honor.
We'll set it for plea. Thank you.
Thank you, Your Honor.
No problem. Any additional matters?
You're
for the
feeling
record?
better.
No, much better. Any additional matters for the record?
Not from the people, Your Honor.
Not from the defendant. Thank you, Your Honor.
You're all set. Okay, we have you seen Mr. Lee?
I've not seen this.
I think I saw him over at 24.
Speaking, that's about
And
it.
then Mr. Palmer has Daryl Ford. What are we doing with that one?
It's my understanding that Daryl Ford will be running. Mr. Palmer is trying to talk to him about whether he really wants to do that.
It's being brought up now.
I haven't heard from Mr. Palmer about
Yeah,
it
we haven't
since
brought up.
before, but
On the record in the matter of the state of Michigan versus Daryl Ford 25-02556 appearance, please.
Thank you, Your Honor. Cassidy, could you just for the people?
Thank you, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Mr. Daryl Ford, the gentleman standing to my right.
Mr. Ford was scheduled today for a preliminary examination on assault with intent to create bodily harm and weapons charges. How are we proceeding today?
Your Honor, it's my understanding that the defendant intends to reject the offer for waiver at this time. The people will hold that offer open until I call my first witness, if it's all right with the court. Once we're done with that, then it will be rejected.
The offer was for him to waive and do what?
Yes, and I'm about to get into that. So the offer is that the defendant will waive his right to preliminary exam with consent to the charge be amended to reflect only the following counts. So that's 2 counts of felonious assault, 1 count of discharge from a vehicle, 1 count of prohibited person in possession, 1 count of CCW, and 4 counts of felony firearm with a habitual 4th offender notice remaining, meaning that essentially 1 through 3 would be dismissed in exchange for the 3 new lower penalty counts. This waiver would accompany a preservation of an offer that was open until the first pretrial conference in circuit court. The preserved offer would have been a plea to 1 count of discharge from a vehicle and 1 count of felony firearm as a habitual second offender. And rejection of this offer means that the habitual 4th offender notice will remain, that the people intend to bind over on the complaint that adds 6 more felony counts. And the 6 added counts would be the ones we would have amended to instead, which would be the 2 FAs, the 1 discharge from a vehicle, and FFs attached to each of those for a total of 15 divines over.
Thank you, Mr. Palmer.
Thank you, Judge. If I could just have one quick
Take your
second.
time, but don't get my water bottle.
I don't have a. You're right. I guess when you say.
Oh, yeah, yeah, okay. Eddie, one, I missed one.
I'm not glad. Another one. I think she's a cheap.
I'll explain that accident later.
What in the world? What's happening? Sorry, your cheese ball working here and I didn't know about?
I thought I put the ball up yesterday.
Lord.
Oh, Lord.
But it has to be your.
I came back
You
here
understand?
yesterday. And you can't, I can't.
Okay, glad we.
Your Honor.
Yeah.
Sorry, we're back on the record.
Yes, we're on record.
Thank you. Judge, after consultation with Mr. Ford about the addition of charges, Mr. Ford has now elected to waive his preliminary examination today. He understands, I just want to place some things on the record. He understands that this is a waiver of his examination, only it does not preclude him, I guess, from further negotiations at the circuit court level if people are open to that. And of course, it does not preclude him from having a jury trial if a negotiated resolution cannot be reached. He would still retain all of his trial rights. It is simply a waiver of preliminary examination. Additionally, Mr. Ford, and I anticipate that the court will inquire about this, but Mr. Ford understands that once he waives his preliminary examination, he can't have it back. If I may approach?
Yes, thank you.
Thank you. Thank you.
And Mr. Ford, no one's forcing you to waive your exam, correct? No one's coercing you to waive your exam? Or promises, other than what's stated on the record if you waive your exam?
So have you signed it? want to make sure I read this to you so you fully understand what it is you're signing before you do it, okay? It says. You, the defendant, understand that you have the right to employ an attorney. You can request a court appointed attorney if you can otherwise employ one. And you have the right to a preliminary examination where it must be shown that crime is committed, probable cause, and that's the way lower standard to charge you with the crime. Voluntarily waiving. Okay. So I may approach again, Judge.
No problem. Your waiver is freely and voluntarily made. The bind over date is going to be the 24th of October. That's the date the circuit court's going to receive the file from this court. It's not a court date for you, okay? Your next court date will be a pretrial in the circuit court. Your attorney will be made aware of that. You stay in contact with him, okay? Do you have any questions, sir? Any additional matters for the record?
The court need the PAC codes for the amendments.
I do not need the package. You have to give us an amended, how many you said you were adding 6 different ones or 3?
It would be 6 being added that are different.
Yeah, you're gonna have to write that down. Just give it
I
to
do
me.
have it. Yep.
But I think that they're, just to be clear, they're dismissing some bigger charges.
Yes, so I'm
Because
gonna
he
cross out
waived,
them. Yes, yes.
they're dismissing some and reducing to lower charges.
Correct. And
Yeah,
I'm
if you
gonna,
could write out what you're dismissing and then what you're adding, then I can write it into the, on the court's way here for the clerk's office. And then, do we know where Mr. Lee is? Oh, he's been all over. I saw him telling the prosecutor from Florida did something too. He's been all over.
Yeah, I think they've got him scheduled in all 4
Yeah.
courts this morning.
Yeah,
he's-
so I think he's running. I don't want to bring his client up if he's not ready, so we can just take Mr. Ford down.
Thank you, just for all the approach, okay.
no, I don't have anything on there. No, that was gonna be only for one shot. That's what it listed on
Oh,
the
okay,
link,
okay,
yes.
gotcha, yep.
Thank you.
Mhm.
Picked it up like that.
Yeah.
We're saying the same page, so that was great.
How long? I knew I recognized that. That was Kyle Payson. I knew I recognized that. You can see it. This is the state of Michigan versus Jumar Tarasu, 25-01317, appearance please.
Thank you, Your Honor. Kathy, chief this for the people.
Assistant Public Defender John Lee on behalf of Jumer Terrace.
Okay, Mr. Tarasu is present here in court for preliminary examination. This is for larceny in a building and then breaking and entering a building with intent. How are we proceeding?
It's my understanding that the defendant intends to waive his right to preliminary exam at this time to continue pursuing global offers in circuit court.
Counsel?
That is accurate, Your Honor.
Mr. Tarasu, you understand that you have the right to have a preliminary examination here in the district court?
Yes, Your Honor.
You understand that you have the right to require the prosecutor establish sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony.
Yes, Your Honor.
You wish to unconditionally waive your right to that exam today?
Yes, Your Honor.
Is anyone coercing you to do that? Anyone coercing you to do it?
No, Your Honor.
Any promises if you waive your exam?
No, Your Honor.
You will find over date of September 24th. That's the date the circuit court receives the file from the district court, not the date that you need to appear in court, okay?
Okay, Your Honor.
Your next court date will be a pre-trial. Your attorney will be made aware of that, so you'll be in contact with him, okay?
Okay.
If you have any questions?
No, Your Honor.
He was remanded on bench warrants for multiple failures to appear. Are we addressing bond at this time?
The people have no reason to respond, though, if the defense doesn't reserve right to make an argument on that.
Your Honor, we would like to request bond. Mr. Terrace had some issues in appearing before, but assures me that he understands and will prioritize being organized and knowing when he's supposed to appear. This being a nonviolent offense, we ask the court to set a bond.
Mr. Terrace was supposed to appear on the 8th of August. He had no contact with his attorney, even though he provided a phone number to the court, then failed to appear in court. Then he was supposed to appear for a preliminary examination. Well, he appeared after that. He was rearranged by the magistrate. He said he forgot about it. So he was reset for exam on the 28th. Again, no contact with his public defender, failed to appear. So the court had to remand him to get him here. Where do you live, sir?
Pennsylvania.
What's the address?
I believe it's 1828.
You believe it's 1828?
Yes, Your Honor.
What is 1512 South Pennsylvania? Who lives there?
My mother.
Okay, you don't live there though, correct?
No, I do.
Well, why did you say you believe it was 1828?
Because I don't know the exact number in my head.
Okay, so did you just make that number up?
That's why I thought it is, because it's some number that matches like 1828. I'm not sure.
1828 and 1512 are not the same.
No.
They're not even next to each other.
I don't know the exact number on top of my head. No.
How long have you been living there?
A couple months.
What's your phone number?
I don't got my phone to see my number in there. But that's all.
Excuse me?
Huh?
You don't have what?
My phone to see my number.
You don't know your phone number?
No, man.
Why not?
Because I just knew phone number I got.
When did you get it?
Before I got arrested.
You've given us two different numbers so far since July, and now you don't know your phone number. We don't even know where he's sleeping. We don't even know what number he is. He can't keep up with his court dates. You can't keep up with your phone number. You sure enough are not keeping up with your court dates. You can make a bond motion at circuit court. It's all set.
Thank you, Your Honor.
So